Now, from Austin, Texas, Politics with the Big Dogs, and your host, Anthony Holm.
This is Anthony Holm. You're listening to Politics with the Big Dog, and we have one of my heroes, Edward Blum, who has led the charge against racism in America, particularly in the university system, but well outside of that for at least the last 2 decades, perhaps 3, through his organization, Students for Fair Admissions. Edward, thank you for joining us today.
I'm delighted to be here. Thanks for having me.
I want us to talk about your organization and what you've done. I think I met you in 1997 in Houston, and I might have a year off, but I have followed you from afar, and it's just been incredible, the success that you guys have had. I think many people in America will have heard about your success suing Harvard's racist admission policy. And after many years in the court system, the U.S. Supreme Court said it was fundamentally flawed and racist. So let's talk about that, but let's also talk about the journey, because you are one of the leading citizen activists in America of this generation, and we want to hear your story.
So my activities began with an unintended but wonderful miracle. And the miracle was that my daughter was accepted to college. This was in 1989. My wife and I were business people living in a kind of a garden variety suburb of Houston. Found ourselves as empty nesters, as many kind of middle-aged parents find themselves. We decided we wanted to move from the suburbs into more of the inner city of Houston, near Rice University, near the museum districts, because we liked the downtown entertainment venues and we just wanted to be closer to those events. I went to vote for the first time in my new home near Rice, and the Republican Party in 1990 had not fielded a candidate to run against the incumbent congressional candidate in the 18th congressional district, which was my new district. That incumbent was named Craig Washington. He had been in the Texas legislature and then moved up to take Barbara Jordan's place when she no longer served. And I found it astonishing that nearly 600,000 people didn't have a choice in who their congressman would be. They couldn't cast a vote for anybody other than the incumbent. 2 years later, I am the Republican nominee running to represent the 18th congressional district of Texas. I had no real long-term ambitions to serve in a public elected capacity, but now here I am in the thick of electoral politics. My wife and I knew that we wouldn't be inundated with campaign contributions because the district that we were running to represent was a majority district. There was about 50% plus African American, and then the other 50% divided about evenly between whites and Hispanics. And it's nice to have somebody running, but they're not going to win. So we decided, because campaign contributions were not pouring through the door, to go door to door, meeting the voters of the 18th congressional district. And my wife and I and our volunteers probably knocked on nearly 20,000 doors during that close to 1-year campaign. This was at a time, Anthony, when people would actually open their doors when they saw somebody dressed in a coat and tie, handing out campaign literature and just talking about the neighborhood and Congress and the state of the economy and things like that. The one thing that we noticed was that on one side of a garden variety Houston suburban street, there may have been 3 or 4 homes that were occupied by African-American families. Those homes were drawn into the 18th congressional district. Yet on the other side of the street, same street, there were 3 or 4 homes, or maybe a small apartment complex, that were mostly Hispanics that lived over there. Garcia and Hernandez and Villarreal, and those families were drawn into a different congressional district. And then if you walked up another block or so, there were a grouping of homes where white people lived. So block by block, it seemed like almost house by house, the Texas legislature identified these residents by their race and ethnicity and then drew them into different congressional districts based upon that race and ethnicity. So African Americans were harvested out of multiracial, multi-ethnic neighborhoods and put into the 18th congressional district. And this just didn't happen in a few neighborhoods, Spring Branch and Acres Homes and things like that. This happened all over, so that the 18th congressional district looked like this bug splat that went 30 miles up the northeast part of Harris County, 19 miles down the southeast part of Harris County, blobbed around the downtown area in the 5th Ward and Acres Homes, so that when you looked at the 18th congressional district, you really couldn't tell if you were in the district or not. And it wasn't just the 18th congressional district. It was the Hispanic congressional district and the white congressional district. And if you went to Dallas, they did the same thing there. If you went to San Antonio, they did the same thing there. So this was, in my opinion, not only legally questionable, but it weakened the neighborhood structure. It weakened the commonality that all of those residents had. These residents, when you talk to them about, what's going on in this neighborhood, they would talk about crime in the neighborhood. They would talk about schools in the neighborhood. They would talk about infrastructure in the neighborhood. That's what they were worried about. These kinds of, jobs, those concerns were the same whether you were Hispanic or Black or white. You were worried about, the safety of the schools that you were sending your children to, because all of those houses, those neighborhoods were in a school attendance zone. All those kids attended the same elementary school, the same junior high, the same high school, but they were drawn into different districts.
Could you imagine the outrage if one side of the street went to school A and the children on the other side of the street went to school B and it was based on race? Like, there would be a national news story.
Absolutely.
In the early 1990s, the congressional districts and I believe the state legislative districts were chopped up in such a way. And of course, at the time, it was controlled by Democrats. There was a lot of news recently in Texas over congressional redistricting here while it's been controlled by Republicans. But this has been an event and a norm and a thread through society for many, many decades, independent of party affiliation.
You're absolutely right. So I lost the election. I didn't serve in Congress. I did garner 10% more of the vote than George Herbert Walker Bush did in that district, and that margin, I think, energized another congressional candidate, a Democrat, to challenge the incumbent and beat him in the 1994 primary. But this business of just divvying us up by race, house by house, block by block, I had never sued anybody in my life. I am now, at my age, I think I was maybe 39 or 40. I had never been sued in my life. So I pulled together some friends and we filed a lawsuit challenging the constitutionality of the Texas redistricting plan of 1992. I was able to recruit one paid attorney who was a real estate attorney from Monroe, Louisiana. He agreed to represent us for $7,000 a month for 6 months. That's all the money I had that I could budget for this. And there were a handful of Houston lawyers that just volunteered, even though they had no election law experience. So we sued the state of Texas. It was a case styled Bush versus Richards. You were absolutely right. Ann Richards was the Democrat governor at the time. That case was argued before a 3-judge panel in Houston. The trial lasted a week. Our little ragtag team went up against Texas Attorney General, and that very well supplied office, the United States intervened. Department of Justice lawyers came in. NAACP and MALDEF came in. There must have been 50 lawyers representing the state, and I think there were like 4 lawyers representing myself and my buddies. About 4 months after the trial ended, the 3-judge panel that heard the case sided for us. They said that the 1992 Congressional Redistricting Plan was an unconstitutional gerrymander, and the state of Texas was now compelled to redraw these districts, keeping neighborhoods compact and contiguous and recognizing communities of interest.
I've got to intervene. I had no idea. I didn't meet you at this time. I didn't understand this background. I know you as the leader of Students for Fair Admissions. This is fascinating. And if you're joining us midstream, folks, this is Anthony Holm, Politics with a Big Dog, and we're talking to Edward Blum, one of the great champions against racism in America the last 35 years, and came out of Houston, Texas, has been driving the national force and fair admissions in universities, and we're hearing how he got there. Here we are in 1994. You all fight the state, you fight everybody, and it turns out that the court side with you and say, this is a gerrymandered, you got to redraw the districts in Texas, and you are not a lawyer. You had no interest in this other than fairness and decency and knowing that racism is wrong in America.
Well, Anthony, something remarkable happened after a three-judge panel in Houston found that the Texas plan was unconstitutional. Texas appealed it to the U.S. Supreme Court, and the U.S. Supreme Court took the case. Now I've got a ragtag team that's about to argue a Supreme Court case. So I wisely found a much larger Washington, D.C. law firm to argue the case. And we did. About 6 months after we argued the case before the U.S. Supreme Court, the U.S. Supreme Court upheld the lower court decision and compelled the state of Texas to redraw. It was probably about 15 of the 33 congressional districts throughout the state. That was really very gratifying that someone from my background was able to do this with the help of volunteers and wonderful friends.
I'm going to interject because your background is educated, financially successful, suburbanite American living their life who sees a wrong and says, we need to go and do something about this. It's just fundamentally wrong, fundamentally unfair. And we have 330 million Americans, and many of us grouse about things in government and the legal system. But one person, really with no material training, I'm not discounting who you were. You were a smart guy and a banker and an empty nester, a failed congressional candidate who only seemingly ran because we ought to have a choice. A voter should at least have somebody. You're in like a 70-30 district. You know you'd never win. And you file kind of a crazy lawsuit with a bunch of volunteers, and you end up in front of the U.S. Supreme Court, and they rule for you. This is incredible. This is what every American who believes in the Constitution should feel empowered to do.
The court systems are complex and they're expensive, but there are organizations that if you feel like you have been wronged, or if the state has done something, a corporation is doing something, you can find a lawyer. Federalist Society, lots of not-for-profit legal organizations are there to help. Once we had that Supreme Court victory in the Texas case, I took that kind of ragtag volunteer group, and there were a couple of other now election law attorneys, and we took it on the road. I found a congressional candidate in New York, like me, who ran in 1992. I said, would you like to challenge the New York redistricting plan? He was Puerto Rican. He said, yes. So we went up to New York. He was the plaintiff. We sued New York. We sued Virginia. We sued South Carolina. We changed the redistricting plans of 5 or 6 states, a couple of legislative bodies. So now I feel, at age 41 or 42 that, all right, I'm in the municipal bond business. I've taken this one case to the Supreme Court. It is so gratifying that going back full time to the municipal bond business just didn't seem to have that much cachet. It didn't have the pull and the satisfaction. It wasn't as meaningful as it once was, is what I was doing. So, Anthony, that was the beginning of my life in the law. So from that first case, Bush versus Vera, decided in 1995, I believe, all the way through 2023, I have Sherpa'd, I'm the Sherpa here, of 8 cases that have been heard by the U.S. Supreme Court.
And not a lawyer, certainly took a pay cut, but found passion and have changed the lives of at least tens of thousands, probably hundreds of thousands of young Americans, perhaps millions, and will, none of whom you'll ever know, and they won't know you, but they're going to have a better opportunity because of what you have done. And thank you for doing it. Now tell us about it.
So the other cases involved areas of election law that are a little arcane, but were important, having to do with certain provisions of the Voting Rights Act. Those provisions, in my opinion, created racially gerrymandered districts. This was a provision in the law that over the years had been reinterpreted to compel states to draw, African-American districts, Hispanic districts, white districts. So that was challenged, and the Supreme Court found in 2023 in a case called Shelby County, Alabama versus Holder, that provision of the Voting Rights Act was no longer operative. So that was very gratifying, and that was very infuriating to a lot of our friends on the other side. The day that opinion came out in 2013, President Obama held a press conference, very angry. Attorney General Holder held a press conference, was very angry. But that case has not been revisited by Congress, and I don't think it will be.
Prior to that, all of us working in this space, and in part because of your efforts, were acutely aware that the Voting Rights Act, as written, was fundamentally racist. And folks don't want to say that, but that's what it is. It was carving up, it was instructing. The way it's been interpreted by courts is you must create X number of African-American districts. You must create X number of Hispanic districts. That's fundamental racism. If you're putting people in categories by race, that is the definition of racism, and it flies in the face of Brown v. Board of Education, every other tenet of racial equality that we have recognized and advocated for as Americans. And nobody had the courage in Congress to go and fight it. I talked to a number of congressmen who said, yes, but I can't do that. I can't do that. Your efforts at the courts did it for them.
Anthony, following up on your experience, I left Texas in 2000 when George W. Bush became president, and I moved to Washington and affiliated with the American Enterprise Institute, AEI, and started a more formal legal advocacy foundation or organization. And when that provision of the Voting Rights Act was up for reauthorization, I went to Capitol Hill and testified and talked to the White House and talked to senators and congressmen. And it was funny because the vote was 33 for my side, and I don't know how many more would that have been? 300 and something. It was 33 to whatever the number is
in the House. So yeah, in 400 House members.
Yeah, right. And then in the Senate, it was 98-0. So 98 senators, including our friends on the right, voted to reauthorize this, and it was celebrated at the White House, even though
it's fundamentally wrong.
I think people recognized it was fundamentally wrong, but there may have been too high of a price to pay politically to rewrite the bill so that it didn't compel this divvying us up by race. So failure to convince Congress led to the filing of Shelby County versus Holder, which courts then did what Congress should have done.
Let's go into the university system. When did you first take up the mantle against the universities racist policies. And again, if you're joining us midstream, this is Edward Blum, who's the champion of racial equality in America, most recently through Students for Fair Admissions, to using the legal system and the judicial outcomes to ensure that all applicants to universities in Texas have a fair shot. So we are moving to Students for Fair Admissions.
So I'm going to back up just a little bit. I'm not going to take you into the bones in the ground the way James Michener would in one of his novels, but this story begins in Texas. Students for Fair Admissions would not have been an organization and would not have brought our case against Harvard and the University of North Carolina had it not been for what happened in Texas. And that began in 1992 when Cheryl Hopwood sued the University of Texas School of Law, arguing that race should not be a factor in college admissions. She won her case, and race was eliminated by the Fifth Circuit in Texas, Louisiana, and Mississippi. When that happened, the African American enrollment and Hispanic enrollment at the University of Texas dropped precipitously, and the Texas legislature passed something called the Top 10% Plan, which allowed, and it's still in place, not a 10% plan, but I think it's a 6% plan.
I believe, yeah. Yep.
Any kid graduating in the top 6% of his or her class, regardless of their SAT or ACT or anything, would be automatically admitted to the University of Texas or any Texas public school. And that bill surged the percentages of African Americans and Hispanics at UT. As it turns out, that bill was more effective than race-based affirmative action. So when the University of Michigan cases came to the Supreme Court in 2003, this was two cases where two women had applied, one to the University of Michigan School of Law, another to the undergraduate program. Grutter versus Bollinger and Gratz versus Bollinger, 2003, the Supreme Court then did something very sad. They said that race can be an element in college admissions. And that then the University of Texas reintroduced race as an element in their admissions policies on top of the Top 10% Plan. Even though the Top 10% Plan was more effective than race, UT decided they wanted both.
And so, for our listeners, many of us are familiar with Brown v. Board of Education and the fundamental statement that separate but equal is fundamentally unequal, or is inherently unequal, I believe it is. I'll say a paraphrase. But what happened in 2003 by the U.S. Supreme Court was, hey, you can use race as a factor. And what does that mean? That means you're going to have separate admissions tracks, because if you're an African American, you're going to be admitted with lower standards. And if you're an Anglo, you need higher standards to have an opportunity for admission. So somebody like me who's a white male, though I came out of, I have a GED, I'm a high school dropout. My mother got pregnant at 17, raised by a single mom, and every government aid program known for the first many years. And in a trailer park, I might be competing and at an academic disadvantage with an African American or a Latino raised by doctors or a two-parent family. That is just a statement of fact. The U.S. Supreme Court reintroduced race as a deciding factor into admissions and otherwise in 2003, which is shocking to me. And I'm sorry to intervene, but please continue from there.
You're absolutely right. It was devastating opinion to the foundation of equal protection in this country. It meant that your skin color has a great bearing on how society should treat you. It was authored by Justice Sandra Day O'Connor. She included that, it's likely that this kind of discrimination will only last 25 years because then won't be necessary. So the fact that the University of Texas had this race-neutral policy, the top 10%, but immediately the day of the opinion out of the Supreme Court in the Michigan case, the president held a press conference and said, we're reintroducing race. We're allowed to do it now. Well, 3 years later, a young woman named Abigail Fisher, who lived in Sugar Land, applied to the University of Texas. She was in the 11th percentile of her graduating class, and she was rejected from UT. And I asked Abby if she would let us represent her in a challenge to the reintroduction of race at the University of Texas. We weren't, in 2008, the year that she sued, we weren't looking to overturn what the court had just done 5 years earlier. We just wanted the court to acknowledge that, hey, the reintroduction of race on top of this race-neutral plan, which was very successful, that is in conflict with what the Supreme Court gave us in those Michigan cases. So Abby agreed to sue.
Be a plaintiff. Yeah.
Be a plaintiff. It was Abigail Fisher versus the University of Texas. Her case went to trial. She won. She lost at the district court. She lost at the Court of Federal Appeals. She appealed to the Supreme Court, and the Supreme Court took her case. So now Abby Fisher, all of age, I think 22 or 23, has her case first time at the U.S. Supreme Court. The court came down with kind of a muddled opinion in that case, but an important opinion. They wrote that colleges and universities can use race in their admissions policies, and we knew that would be part of it. But a college or university has to overcome some very high hurdles before they can use race. And the University of Texas doesn't appear to have overcome those high hurdles. So here is a new standard of review. Here is a new rule that we, the Supreme Court, are implementing in the Abby Fisher case. Now take this rule and go back to the lower courts and see what UT did. It was my opinion, and the opinion of a lot of smart lawyers that I worked with now, that new higher hurdle would be basically the end of race-based affirmative action in college admissions. So that opinion came out in 2013. In 2014, I founded Students for Fair Admissions with the goal of revisiting the 2003 opinion in the Michigan cases that allowed race to be a factor. So that, Anthony, was the beginning of the attempt to end race-based affirmative action, to overturn the earlier decision of 2013.
And every student and family in America seeking achievement also owes a great thanks to Abigail Fisher, because she didn't get into UT. She had to go someplace else to continue her college education. It would have been so much easier to leave this behind and not be on the cover of all the newspapers and not have your name associated with litigation. Yet she was brave and she fought. She said, this is fundamentally wrong, and we're going to go see what happens. And the U.S. Supreme Court said, guess what, guys? It's wrong. Here's a new rule. And we all believed in 2013 that this bastion of racism in America, the university system, would be barred from continuing to use race-based markers for their admission process. But yet, we were
Abby is a young woman of enormous courage and fortitude. And, I'd like to think of Abby as Abby would march into hell for a heavenly cause. She, social media around this time was starting to take off. She was a victim of a lot of nasty social media, phone calls, emails. She was worried about her employment possibilities with her name out there. So God love Abby. Without Abby, I'm not sure we would have ever had the right set of circumstances to have the court revisit and end race-based affirmative action in 2023.
And most recently, you guys took Harvard and took them to task and won top to bottom, as I understand it. If I'm in error here, you aren't going to hurt my feelings. Let's get it straight for the listeners. As I read the Harvard ruling, affirmatively illegal, Harvard's violated the law. But if somebody wants to write a essay with their admission and talk about how their race, how they overcame struggles about their race, and you can use that. Is that a fair assessment in reading?
Yes, it's complex. We back up to 2014. The decision is now made to challenge Harvard and challenge the University of North Carolina. Harvard, America's oldest private university. The University of North Carolina, America's oldest public university. So you've got two different, schools. They both fall under certain legal provisions, but there are some distinctions because one's private, one's public. Because Abby had gone through such harassment, I didn't want to go to another kid and say, join this lawsuit. In Harvard, it would have been something like, I don't know, I'm going to make this name up. It would have been Linda Wong versus Harvard. And in UNC, it could have been, Robert Shapiro versus UNC. So Students for Fair Admissions was formed. I formed this group as a membership organization. So you could join the membership organization, pay a membership fee, and the membership organization then had standing to sue these universities so that our members' names would be sheltered from the public. Harvard's lawyers couldn't release who they were. They were deposed, but those depositions had all of their identities hidden. Anything that would suggest who they were was hidden. So to this day, nobody knows I guess maybe close to 36 students that over a 10-year period joined Students for Fair Admissions to sue Harvard. We sued Harvard and UNC in 2014. We went to trial. There was a 3-week trial in Boston. In 2018, appeals. The Supreme Court finally said we'll take the case in 2022. It was argued in 2022. On Halloween 2022, and then June 29th, 2023, nearly 10 years, Anthony, 10 years after we filed, the Supreme Court ruled 6-3 in our favor to end the use of race in college admissions. That's an enormous outcome, not only in the area of college admissions, but it has energized the movement to end race in other areas of public policy. Employment, whether you're hired because of your race, whether you're fired because of your race, whether you're promoted because of your race, whether you get a contract because you're a racial minority. All of these things now, there are dozens and dozens of lawsuits that have come on the heels of the Harvard and UNC cases because conservative legal movement is now energized to bring these.
And because of the leadership of you and the courage of these students, you said, let's pick an arbitrary name for Harvard, be Wong. And why do we say an Asian name? Because Asians qualified and had much higher scores than many of the students admitted who were African-American or Latino or otherwise, who just were not Asian. And Harvard said, we can't have that. I mean, we don't look at the NFL and say it's got to have X number of Asians, it's got to have X number of whites, it has to have X number of Latinos, or the NBA. But we, and particularly the university system in America, said, oh, it's perfectly fine. We know better than you. We'll just slice the pie. And this piece is going to be 33%. It's going to be African-American, independent of SATs, independent of scores. And there's too many Asians, so we're gonna compress that, even though they had the highest scores, even though they had the highest grades. I mean, either we believe in the merit system in America or we don't. And the university system and many of the things you just named, contracts in government, employment. I saw some litigation around charities. Tell us about that.
There were a number of organizations that made contractual donations to individuals who wanted to start businesses or continue funding businesses. And it's perfectly legal for, Anthony Holm to say, all right, I've got a pocket full of money. I'm going to walk down the street and give it away. And I'm only going to give it to, Irish Catholics. You can do that. Hand them the money. That's fine. Blum can say, I'm going to only fund Jewish endeavors. That's fine. What I can't do is hold out contractual obligations in which I say, I will give you money or I'll invest in your business, but you have to sign this contract. And oh, by the way, no whites or Asians need apply. That runs afoul of some of our oldest civil rights laws going back to the post-Civil War era. We sent a letter to the IRS because the Gates Foundation had a scholarship that was open only to racial minorities. In order to receive this money, you had to agree, sign a contract with the Gates Foundation when you accepted this money. So that program had a contractual basis, and that ran afoul of our civil rights laws. Now, fortunately, we didn't sue the Gates Foundation. We brought this to the attention of the IRS, and within, I don't know, Anthony, maybe 4 or 5 days, the Gates Foundation took out a white surrender flag and waved it and said, okay, we're changing this, which was fine. They're going to offer this scholarship to every needy student. Qualify academically and you come from a modest or a disadvantaged background. It doesn't matter if you're Black or you're Asian or you're white or you're Hispanic or you're Native American or you're Hawaiian. Just you deserve a shot at that money. That was a very satisfying project that we took on.
So after these rulings and the success that you guys have had, though it's been a 35-ish year fight and you've dedicated your adult life to it. Thank you again for doing that. You all are now just sending notices, as I understand it. This violates this holding, this law, and changes is happening. The Gates Foundation, one of the largest foundations in America. I mean, imagine this, people. We are giving them tax breaks. We're going to say, oh no, you don't have to pay taxes on these money. And they're turning around and taking these monies and saying, we'll give it to you so long as you aren't white. Effectively, that's what they're doing. That's at both the disadvantage of a huge portion of America, but also we're subsidizing that since we're not taxing those monies. That is creating a tax system that is fundamentally racist. It's a niche area, but give us a scale of the impact. My suspicion is you guys are just sending out letters left and right and people are waving white flags.
Since the Harvard opinion came out a little over 2 years ago, June 29th, 2023, Students for Fair Admissions and a new group that I formed called the American Alliance for Equal Rights, we have filed 22 different lawsuits. 22 lawsuits in a little over 2 years. No wonder I'm still drinking 2 Red Bulls, every morning at 4:30. And those lawsuits, we sued 3 of America's largest international law firms. Perkins Coie, Morrison Forrester, Winston and Strawn. Those law firms had summer internships programs for first-year law students. If you're finishing up your first year of law school and you wanted to intern at one of these very prestigious law firms, you could apply, but you couldn't apply if you were white. It was only for racial minorities. So we sued all 3 of those. And within, a couple of months, they all surrendered. They said, okay, we're done with this. We're going to open this up. That I thought was a particularly interesting set of lawsuits because these law firms, of course, give legal advice to America's largest corporations. They're corporate lawyers. And, it was quite ironic that these firms giving general counsel advice at firms like Apple and Microsoft and NVIDIA and Johnson & Johnson and hundreds of others the law firm itself is breaking the law. So how good is their advice to these corporations? So that was
And I'm going to intervene for a moment because I wanted full disclosure for the listeners. I went to UT Law School. I was there in 2002, 2003, where a lot of this litigation was going on. And what I recall, that doesn't mean I'm recalling it accurately, but I recall a group of students in my law class saying, yeah, they let me into UT and I hadn't decided where I was going to go. And it was these type of law firms. I don't remember which one it was, but it was the big one that everybody wants where you make a lot of money every single week. They sent me a letter and said, if I went to UT Law, that I already had a spot at this law firm making X dollars. And they were all African-American students. And that's perfectly fine if that's who the law firm wants to hire, but it isn't fine to use it as an inducement to attend UT Law and not allow somebody like me to compete. I'm a high school dropout with a single mom who was 17 and came out of a trailer park. Why shouldn't I or anybody else similarly situated have a fair shot at opportunity in America? And anecdotally, I also very rarely did I go to the professor's office hours or class or to ask a question here and there. I wasn't as engaged as I could have been, but I did a few times. And sometimes I would see the professors effectively doing study groups for a group of African Americans or a group of Latinos. And they would say, no, I'm not available right now. And I learned through my peers that, oh yeah, once a week we get tutored by the professor on property. And once a week we get, so the university system was just giving tremendous advantage or equally disadvantage to people who look like us or look like me, at least. That was my anecdotal experience, and I wanted to flag that. But please continue. 23 lawsuits. And I also want to make sure that people can find the American Alliance for Equal Rights and Students for Fair Admissions. So we need to make sure we get their websites out. But continue, please, again. So you shut down those law firms who are advising corporate America to violate the law, and they're doing it internally.
Yes, that's right. That was I thought that was those three were quite unique. And the great thing about, Anthony, better than anyone, lawsuits have major consequences. We sued those three, but there were probably another 24 that we didn't sue. One or two we sent letters to, but out just on their own within days of Morrison Forster and especially Perkins Coie dropping these racial requirements. All these other law firms made announcements that their programs were being changed also. It wasn't just those three that were doing it. There were dozens, and the vast majority, to my knowledge, have stopped that. So, and over the last, in 2024, 25, we've sued McDonald's, Southwest Airlines, American Airlines. We sued the Smithsonian Museum in Washington, D.C. The Smithsonian had a program, a wonderful summer program, but it was only open to Hispanics. No African Americans, no Asians, only Hispanics.
America's national museum system only available to Hispanics. That's just fundamentally un-American. What are we doing, people? What did McDonald's? What are these airlines doing?
Well, the airlines. I'll tell you what Southwest had because it's quite unique. If you were a Hispanic student and your home was near a Southwest Airlines airport, within a certain distance, and your college was within a certain distance of a Southwest Airlines airport hub, you could get a free trip. Southwest would fly you for free from college back home and from home back to college. And they had I don't know how many dozens and dozens of these free trips that they would give away every year. But if you were at Spelman College in Atlanta and you wanted to fly home to Dallas, you had to pay, even though you were African American. So they ended that. American Airlines had a business program where you could provide services or goods to American Airlines, even though you may have been a higher bid because your company is owned by a racial minority, then you could win the bid even though your price was high. So, and I can't even remember all of them, but if you give me a minute, I could pull up the list. But if you go to our website, AmericanAllianceForEqualRights.org, you can click on our cases and click on newsroom because I've generally listed all of the cases that we have filed there. So the last one I want to tell you about, I think, it was very high profile. And
okay, hold on. I'm going to intervene then for a second, because on your website, if somebody believes they have an instance of a racial disparity or a racial illegality, is there a place for them to submit, hey, look over here, or look where I am working? Is there an engagement opportunity for that?
There is indeed. There is a tell us your story. If you have observed something that you think is unfair and illegal, send it to us. Your name will never be disclosed. And if there is something that the legal team believes is actionable in court, then we'll contact you and tell you, what you can do to end this illegality. We can provide counsel to you at no cost. And you will join the American Alliance for Equal Rights as a member. And your name will never be made public, just like in Students for Fair Admission. So all of the law students that joined the American Alliance for Equal Rights that sued these law firms, nobody knows who they are. They are members. So they're
and then tell us the website for the Students for Fair Admissions.
Yes, Students for Fair Admissions is studentsforfairadmissions.org. And it has the same functionality. If you've applied to a school and you were denied admission and you think something's fishy, we want to hear from you. Tell us about your grades, your activities. Tell us about, what you've done in extracurricular activities, and we'll get back to you. So both of those websites have functionality that the American public can communicate with us.
Thanks.
Students for Fair Admissions, shortly after the opinion came out in the Harvard and UNC cases, we sued over a relatively short period of time the Naval Academy at Annapolis, the U.S. Military Academy at West Point, and the U.S. Air Force Academy in Colorado Springs. So we filed those three lawsuits because those institutions, the court was what I call agnostic on whether race could be used there because they are unique higher educational institutions. Fortunately, all three of those cases now are over. We went to trial in one, and the Trump administration has ended all three, and all three have now entered into what I call sort of consent agreements with Students for Fair Admissions, that their use of race in order to admit kids to Annapolis or West Point were improper and illegal. So that's a big, major step in making sure our military officers are trained based upon their merit and their abilities, not because of their skin color.
And thank you for doing that. You were going to give us the last one, a whiz-bang big offender in the corporate sector, I believe. But I wanted to make sure that everybody heard how to continue their story and share with your organization. So please give us your big whiz-bang one.
I think the most high-profile one that did not surrender, that was really quite distressing, was the American Alliance for Equal Rights versus the Fearless Fund. And if you Google that, American Alliance for Equal Rights versus Fearless Fund, you will see that the Fearless Fund gave money to only Black women, not white women, not Hispanic women, not Black men, but only Black women. And they gave this money to businesses that were owned by Black women. And this was also a contractual agreement. A Fearless Fund made investments, donated these monies, and these corporations owned by Black women had to agree to certain provisions that Fearless Fund.
Give us an example. What's the worst provision?
Well, the contractual arrangement was that, you could not sell your business to a white woman, even though you may want to sell it. You must allow the Fearless Fund to recoup some of the donation, and you must allow Fearless Fund to advertise that they provided you this money, and you have to participate in certain events and things like that. So that
Edward, I got to intervene.
Plan. Yeah,
I got to intervene because you buried the lead, and maybe you were going to get there, and I'm sorry. So we have a fund in America that is giving money only to African-American female business owners. And to accept that money as a condition of it is, and you cannot sell your business to a white person. Is that an accurate statement?
I believe that was part of the contractual agreement, or it had to have the permission of the Fearless Fund. The Fearless Fund might have allowed you to do it, but you just couldn't pick up and do it on your own. So that was one of the more distasteful, elements of all of this. Now, the Fearless Fund they did not surrender. We went to the 11th Circuit, had a trial in front of a district judge. We lost. We then appealed to the 11th Circuit before a 3-judge panel, and we won. During this period of time, the Fearless Fund leaders were on, national TV. It was a very polarizing time. Al Sharpton showed up for these hearings. There was a lot of name calling. I received a lot of, horrible emails and phone calls. And that I would say, of the 22 lawsuits, that was probably the most polarizing. But it was also, I think, one of the most important, because the 11th Circuit looked at what they were doing and ruled against them. And if the 11th Circuit found that these kinds of provisions were unconstitutional and illegal, then it was much easier for us to prevail in other suits.
Race-exclusive programs like the one the Fearless Fund promoted are divisive and illegal, are some of the leads. This is just amazing to me. We're going to give you, African-American female business owner, $20,000, and we're going to put conditions that are based on race as to what you do with your business, your private property in America. Astounding. Thank you for this time. Thank you for what you're doing. Thank you for the advancements of liberty in America. And is there anything that we need to know as we wrap this up?
I would love for your listeners to be a lookout for us. There are policies and programs throughout the country that need to be challenged in court. And these organizations and other organizations throughout the country provide legal representation without anyone's name being made public. This is the only way to fix what is so broken in America in terms of race-based quotas and policies and the like. So thank you, Anthony, for having me today.
Edward Blum, thank you so much. You're a modern day Martin Luther from my perspective. This is an area of society that people just don't want to talk about and want to pretend racism doesn't exist in these programs. You all shine the light on it. Students for Fair Admissions, the bravery of those people, the continuation through American Alliance for Equal Rights, both of them, .org to learn more, to tell your story. And thank you for joining us on Politics with the Big Dogs.
Thanks, Anthony. I enjoyed it.
Politics with the Big Dogs with Anthony Holm is supported in part by the First Amendment Alliance Education Fund. Learn more about today's guest and hear other episodes online in our archive. Visit politicswiththebigdogs.com. If you have a question for Anthony Holm, email Anthony at politicswiththebigdogs.com.